always big trials there in Massachusetts, where a trial date has now been set for the husband, who is accused of killing and dismembering his wife. So this is going to be another good trial that we're going to start watching here on Court TV. Anna Walshe was last seen New Year's Day 2023. Nearly 2 years later, her body has never been found. Anna's husband, Brian, he is charged with her murder. Key evidence in this case centers around the defendant's online searches the day that Anna disappeared. Investigators say that Walshe searched for the best ways to dispose of a body. And what's the best tool for dismemberment? His trial does begin in October of next year. Court TV crime and justice correspondent Matt Johnson has a look at this case against Walshe.
No comment from Brian Walshe after he was charged with the murder of his wife, Anna Walshe, the missing Massachusetts mother of 3 young boys. And while he's not talking, prosecutors are piecing together a timeline of what they say he was doing in the days after her disappearance. Prosecutors say that Anna Walshe was last seen here at her Cohasset home on New Year's Day. Anna was last seen at home between 4 and 5 a.m. by a family member. Walshe told police that he had slept in that morning, but prosecutors say that he was actually awake and searching disturbing topics on his son's iPad.
At 4:55 a.m. on January 1st, he searched how long before a body starts to smell.
The very next day, more Google searches.
There were also more Google searches on January 2nd. At 12:45 p.m., Pat saw best tool to dismember. At 1:10 p.m., can you be charged with murder without a body? At 1:14 p.m., can you identify a body with broken teeth?
Prosecutors say that on January 2nd, Walshe came here to this Home Depot store, located in Rockland, Massachusetts, 9 miles from his house. He spent $450 on cleaning supplies.
Items included cleaning products, mops, brushes.
On January 3rd, prosecutors say Walshe drove to an apartment complex in Abington, 16 miles from his home, where they say surveillance video shows him hoisting a heavy garbage bag into a dumpster. At 4:48 p.m., prosecutors say Walshe drove to a second apartment complex in Abington. And at 5:10 p.m., investigators say he threw items away into a dumpster in Brockton. Then on January 6th and 7th, police searched the Walshe property in Cohasset. Prosecutors collected a lot of evidence in the basement of this home, including DNA blood evidence and 2 knives. On January 8th, Walshe was arrested for misleading police in his wife's missing person investigation. The next day, he was arraigned and pled not guilty. Then on January 17th, prosecutors announced that he would be charged with her murder. The next day, he was back in court.
The defendant is now before the court charged with murder of his wife, Anna Walshe, as well as disinterring of a body.
A hearing was held in the Brian Walshe case yesterday, so let's bring you that hearing now that took place in Massachusetts.
Good afternoon to the lawyers and good afternoon to the defendant. All right, great. So happy to see everyone, and I'm going to go through what I have on my agenda, and then I'll address with you whatever, if I can, address with you whatever questions you have. On my agenda today is to talk about the pending discovery disputes, see if we can make some forward progress on that today, either today in the hearing or if not, ruling in the near future. I want to discuss the scheduling order and where I see this case going in terms of progressing forward and discuss your joint motion that you submitted last week and the preview for that. I guess don't see this case going into 2026 for a trial. I think it should be tried in 2025. I'm certainly going to do my part to make sure that it keeps on track to get us there. And that's due to, in large part, the age of the case and its respective complexity, or not, and the range of cases like it. So I think that it's reasonable to assume that a case such as this one will be tried within 2 years from indictment. On the present schedule we're looking there that you suggested, I think it's coming closer to the 3-year mark, and I think that's a little unnecessary. And nothing gets better with time. People's memories don't get any better, and the case isn't going to get any stronger. People's memories fade over time, and so I've been interested in making sure the case gets tried as efficiently as is possible, respecting the numerous issues that have to be addressed. So we'll talk about that. And then I think attenuate to the motions that have been filed. We're going to need another date, or perhaps need another date on the Rule 17 motions, which I appreciate the defense filed to come up, I assume, based on your earlier pleadings, and third parties may be filing objections to those, so we'll get that on the calendar. With regard to the calendar, I'm happy to come down here today. As you know, I have been specially assigned. I want you to know when we're picking dates for future things that it's highly likely you're going to be traveling. I'll try to travel here when I can, because I know that this is where it is. But you should also build in the expectation that you may be traveling, and the travel in the next 3 months is going to be to Middlesex County, because that's where I'm going to be assigned for the first quarter, and deliberately not far from here, recognizing that I probably will be seeing you a bit between now and whenever we get the case ready for tee up for trial. So let me say that, just so that you sort of have an idea of what my knowledge base is, and I've gone back and tried to listen to a number of the hearings on the case, most notably, I guess, and most importantly, your last hearing before Judge Cannoni, when this issue with regard to, I think as Attorney Tipton said, it was an exhaustive or extensive discovery request came up, and you all thought that you could make some headway, and you did make some headway, although there's some disputes that still linger. At that time, so I listened to that last hearing. I also went back and listened to a hearing on June 24th, in which the parties informed the court that the trial date was too tentative at that point, at least 6 months ago anyway. I have before me now what are the first round of discovery disputes. Those were docketed, just for the record, and as paper number 18, the defendant's motion for discovery of documents related to the district attorney and law enforcement. That then gets updated by your second motion, which I got to be filed on Friday. That's paper number 32. I've gone through those. I've gone through the Commonwealth's oppositions to those. And then also, I received on Friday paper number 31, which is, I'll call it the federal investigation motion, and the Commonwealth's opposition to that, which I just briefly, I got it just as I was coming down the stairways, and I read it, but I haven't given it much thought. The first thing I wrote before I got your opposition was do a TUI request. And so I see that at the end of that, that's exactly what we're doing. We'll get to that in a minute. So I've read all the pleadings. I have looked at some of the law that I want to look at. There's one thing that I didn't get a chance to look at this morning, but I'll hear from you. And perhaps the best way to do it is to just go item by item and identify. I think it pretty clearly now identifies where there's a variance. If you wish to be heard on any of the, and orally, I'll certainly give you the opportunity to do that now. If you want to rest on the papers, that's fine too. I may have questions as we go through them. But why don't we all just turn to paper number 32 and go through those now.
Would you like to start?
Sure.
I think by and large, I'll just rely on this plea that we filed after the Commonwealth.
All right, that was that hearing from Massachusetts that was yesterday, and we wanted to replay that for our viewers. Meanwhile, here in Conway, South Carolina, we are continuing to follow developments in this case here where the defendant, Christopher Duntel, has said that he wants to plead guilty. We'll have all the latest when we come back.
Welcome back to Court TV Live. I'm Julia Janae. Thank you so much for following along with us this afternoon. We have been in several courtrooms today. A lot happening here at Court TV. Our legal correspondent Kelly Craft is going back into the courtroom there in South Carolina, where we are following that breaking news that the defendant in the coroner affair murder trial is deciding to plead out the case. This after the jury had been brought in and we were preparing to cover opening statements. So we will keep you posted on what happens in that courtroom. For now, we are turning our attention to Massachusetts, where a man who's accused of killing his missing wife was back in court yesterday for an important discovery hearing. Brian Walshe is charged with first-degree murder in the presumed death of his wife, Anna. She was last seen on January 1st of 2023 having dinner with her husband and a friend. Investigators say Brian killed Anna that night and spent the following days concealing the crime, including making a fake ransom note. Anna's body has never been found, and her husband, Brian Walshe, was last in court in October, where his lawyers raised questions about the integrity of the Norfolk County's investigation. You'll remember this is the same county that handled the Karen Reed investigation, where there were a lot of questions about ethics and how things were handled. That October hearing for Walshe was continued until yesterday in order to give these parties time to review the large amount of discovery. That includes cell phone data from Trooper Michael Proctor, another name you'll remember. He was the lead investigator in the Reed case. Let's go into court now. We're listening again to that discovery hearing that eventually is going to mention Trooper Proctor.
Under the Commonwealth, and the defense sat down on a number of occasions and worked through this. By and large, Judge, what we're asking, just turning to page 2, paragraph 1, subparagraph A.
Yes.
We continue to ask for disclosure. I understand the reality of this is that they've engaged an attorney who I am familiar with professionally, and like I say in our motion, we don't object to Attorney Sack being assigned to review. So we have no objection to him, and I'm not familiar with Jim Carney, but I have no objection to Jim Carney. It's just that we believe, based on the existing case law and the citations that I've provided in the memorandum, that defense counsel is in the best position to assess the exculpatory nature and the utility of this information, whether it impacts bias, credibility, or the Bowden defense of the conduct of the investigation. And for those reasons, and I'll leave it at that, we ask that this material that the Commonwealth declines to turn over be turned over. Other than that, that's all I'd have to say on that particular issue.
So, Your Honor, I can tell you that not only did we retain Attorney Sack, and he's received the download of the phone. I am also going through the phone, through all of the emails and all of the text messages and anything that could be a statement to try and find Brady material. But I'm also focusing in on Rule 14 statements, and I feel it's my duty under Graham and McFarland to go through this myself and find anything that could be potential bias, but also statements, and I'm doing that. I've focused in on all
I'm
of
happy
it.
to hear that, because you'll find that I try to be as transparent as I can
Yes,
to
Your
both
Honor.
sides. And when I read this, I don't know Attorney Sachs, and I don't know the computer person either, but
Yes, Your Honor.
this is interesting. The Commonwealth gets to delegate its responsibility to review the materials. The defense isn't objecting to it, but I have seen special ADAs, special prosecutors assigned to a case, but I've never seen a third party that's responsible for that. And my initial response, honestly, was, I don't think they can do that. I don't think they can delegate that responsibility to an attorney. But it sounds like you've got belt and suspenders. You're doing it yourself, and it's a backstop or a double check.
Yes, Your Honor.
For the consultant attorney.
That's the purpose of attorney staff. It's not to outsource it, but to double check what the Commonwealth has done.
Okay.
And he's doing it independently.
All right, that's always good to have another set of eyes, I suppose.
Yes, Your Honor.
All right, anything else that you want to talk about with regard to this beyond what's in the papers?
Not beyond what's in the papers, Your Honor. We pointed out that there's sensitive material in there about ongoing investigations. Turn over the phone wholesale would be problematic and could jeopardize ongoing investigations. And as a result, that's one of the key issues of why we can't turn over the phone wholesale.
By the way, what I'm probably going to do is following this hearing is I'm going to give you an omnibus order on discovery. And I'm going to follow your sort of how you set up the issues because it makes sense. And so I'll just go one A, B, C. It makes sense. And I'll probably be doing that more quickly than I thought it was going to be. My trial was supposed to start tomorrow, just tangentially. So I'll have an opportunity to look at this. While it's fresh in my mind, I'll get something out to you.
Yes, Your Honor.
I will tell you that preliminary view on this is that it's the Commonwealth's obligation and that nothing that has happened or that I've read so far turns that on its head. And the idea here that I understand that the defense has a very unique perspective on every piece of evidence that is just a different view than the prosecutor in the case is going to have. But in some ways, I feel like you're inviting me to rewrite the obligations of Rule 14, and I'm not prepared to do that right now based on the information that I know. But that's just my preliminary view, and I want to give some more thought to the arguments that have been made. All right?
May I proceed?
Yes, please.
With regards to paragraph number 2, the request regarding the 3074 pages, I will defer to Attorney Kelly Porges, who at the time when we finish this motion, she will be arguing the motion that addresses that request, I think.
Okay, that's the motion, paper number 31.
Yes.
I will defer on that one.
We don't need to touch upon paragraph 3. We're waiting for a production of those letters. Paragraph 4, we don't need to address because we're withdrawing that at this time.
Right.
Regarding paragraph 6 is really subsumed in Rule 17 that we'll deal with it.
5 is not an issue either, right?
5 is not an issue, I'm sorry. And once again, paragraph 7, that's assumed in the Rule 17 request, I do believe. Number 8, we all agree, at least the Commonwealth and we agree that that's captured in paragraph number 5, the request 5, and we'll need to deal with it. Moving ahead through now to request number 14. What we're trying to do is say that the Commonwealth needs to produce this unless it can make a sufficient showing of what it characterizes as the basis of its argument, that what we're asking for implicates the work product rule. And where I would agree that if the work product rule under 14A5 is in fact implicated, I understand that they would have grounds to say they can't disclose it. But I find it hard to believe that what we're asking for, that the entire universe is captured as work product. And so for those reasons, we ask that that request be allowed in so much as what we've asked for, that they
Why
have not
isn't a
agreed.
good initial step to just say, have them, we commonly see this in civil litigation, but go through, but it's perfectly appropriate for criminal litigation as well, to go through and say, this is the basis for the work, this is, the privilege law, and at least give the defense then the universe of what the responsive documents are, and if it is the Commonwealth's position that they're covered by work product privilege, there'll be enough information that you can make some, and everybody can make some preliminary assessments. And if there are some that still can't get to yes and figure it out through that long, I may then entertain looking at them myself, but I don't think that that's necessary as a first step. What's the Commonwealth's view with regard to privilege law?
Your Honor, there are some items that would be distinctly privileged that we would have the burden to show That being said, the Commonwealth is producing any and all notes written by any of the officers, investigators in this case.
I saw that.
In reaching out to, we've also produced any and all notes and reports from the crime lab. I'm reaching out to OCME to see if they have any additional notes. So the only notes that I can think of that aren't being produced would be mine. And my notes would be on scheduling, strategy, theories, thoughts on the case. And so at this point in time, those would be worked on.
All right. Do you have any objection to putting those in a log?
I would, yes, Your Honor.
Why?
Well, because
I mean, all I'm asking you is from the date, if you have it on your notes. If it's an internal note to yourself, that's it. Internal note, 88 Connor. Date. I'm not asking you what's in there. You can say
it's just not
say as blandly as trial strategy, if that's what it is.
Well, my notes might not reflect dates so much as where I am sitting at my desk writing down theories. So the best I could do would be to say.
I'm not asking for that. Attorney Tipton, right?
No.
You don't want.
So I will go through my notes and see if there is anything that would be discoverable under Rule 14. But as of right now, I can't think of anything, but I will double check, and if it gets to the point that I have to create a log, I will. But I will see if there's anything that contains a statement under 14.
All right, if there's any, if this is a series of notes, it seems like an exercise in futility for you to have them do the log. I'm just saying if there's something more complicated or complex than that, because I'm clearly not giving, you don't want them, you're not gonna get them. So if it's something more than your notes, something going back and forth that reveals strategy, perhaps with you and the investigators, I'm not going to produce that either. But he wants a record, and he's having Attorney Tipton's, credibly saying that he doesn't think that that's the whole universe of what would be out there. It may be.
And so, Your Honor, if we're talking about communications, separate from notes, like I said, I'm going through the emails and text messages that are in the phone. And if there is anything in there that's discoverable under Rule 14 as far as a statement of witness, that's going to be turned over.
Sure.
I intend to be as liberal as possible, understanding what could be 14. But if there is something in there that is trial strategy, and I think that it could get to that point, we're talking about statements in the phone, then I would create a law.
Okay.
I would create a law. That it seems like the appropriate way. If we're talking about the phone itself, when I say the phone, I'm talking about Michael Proctor's work phone.
Right.
I'm not looking to go through every person's phone. I have no knowledge of what is in every other person's phone. But Mr. Proctor's phone is distinctly in the custody and control right now, or the download of it of the district attorney's office.
Okay. All right. So with regard to that, let me finish by saying, any notes, and you'll see this in the omnibus order, any notes that are internal notes to the prosecutor, I don't need to see that on the privilege log. If you want to revisit that, Attorney Tipton, you let me know. If there's something that comes up in the course of your review of the phone that is of the sort, I know it varies a little bit off of what we're talking about right now in this particular request, start making a privilege log.
Yes, sir.
And obviously share it as it's being updated.
Yes, Your Honor.
Okay?
All right, we're hearing a lot inside of this courtroom. We're hearing about Rule 14 there in Massachusetts, which is the rule, criminal procedure rule, that requires that the prosecution disclose things to the defense, especially items that are going to be exculpatory and help the defense's case. And we're also hearing about Trooper Proctor and his phone, and the prosecution saying, I'll turn over what I find is important, what's relevant, but not what is trial strategy, what we have discussed with our lead investigator that may help us make the case against Brian Walshe. Let's take a break. We'll get in for more and hear more about why the defense says we need to understand more about what's on Proctor's phone. Welcome Welcome back to Court TV Live. We are turning our attention to Massachusetts, where we're watching back a discovery hearing in the Massachusetts mom murder trial. Defendant Brian Walshe is accused of killing his wife, Anna, and then dismembering her body. This all happened back in 2023. Brian Walshe was last in court in October. His attorneys were raising questions about the integrity of the Norfolk County investigation. That's the same county that handled the Karen Reed investigation. And in that October hearing, it was continued until yesterday in order to give the parties time to review a lot of discovery. And we're hearing about all of that, including that phone data from Michael Proctor. He was the one that said things on the stand during the Karen Reed trial that he didn't even want to read aloud in court. It was inflammatory, it was offensive, and it has opened up a can of worms for other cases that he was the lead investigator on. Let's go back into court now. We're hearing more of the defense wanting that call log and all of the information from Trooper Proctor's phone.
Focusing our attention on both paragraphs 15 and 16, I think I can just argue these both together.
Sure.
And the gist of this is our request is because the Commonwealth has said they are not in possession of anything and any knowledge at this point, my subparagraph F, really what we're asking for then is to make sure that the Commonwealth, in an affirmative fashion, requests cellular records and text records of the Cohasset police that would impact and bear upon bias, credibility, or the investigation. And I say that because without an inquiry by the Commonwealth of its agents, that being the Cohasset police, we really have no way of seeking this type of information. But more important than that, that given what we now know about what has and may have occurred within the ranks of the Mass State Police assigned to the District Attorney's Office. And I'll just add, without trying to sound hyperbolic about it, but in the Boston Globe today, there was yet another report talking about the failings, if you will, of the Mass State Police in the way it disciplines its officers and the way that certain officers, at least one, was promoted even after significant complaints were made. I think to fulfill McFarland and Graham and the requirement of Mass Rule Criminal Procedure 14A3, that the Commonwealth should be required to inquire specifically whether the Cohasset police have checked, and I'm not talking about all the police officers, I'm talking about the Cohasset police, and there's 3 primary officers involved in the investigation of Mr. Walshe, to see if they have anything that comports with, and who knows if they would disclose it, but I would hope they would, comports with text messages and emails and cellular phone records that indicate a bias, a prejudice, and a lack of professional integrity when it comes to investigating Mr. Walshe. And I will say that it was the Cohasset police, and I'm not casting aspersions on the Cohasset police. I'm just saying that if it's out there, the only way to really get to the bottom of it is if the Commonwealth fulfills its duty of inquiry and then returns back and tells us. I leave it at that.
Who are the 3 Cohasset police officers you speak of?
Schmidt, Lopes, and the third name is eluding me right now.
Connor, when you want to the third name? Or
I would suggest that Harrison Schmidt and Anthony Lopes were the lead investigators for the Cohasset Police Department. Several Cohasset police officers did aid and help. So there, if you were to say that there was like a B team that was helping with the initial investigation, that would be more than just those 2 officers. But Lieutenant Lopes went to Washington, D.C. and did some investigation, and Sergeant Schmidt has been the case officer for the Cohasset Police Department. So, Your Honor, as far as a duty to inquire, I am happy to inquire of the Cohasset Police and the state police investigators to see if there are any statements in text messages or emails that fall under 14 or are exculpatory, for instance, under Brady, McFarland, and Grant. I'm prepared to do that. That being said, cellular records is a bit more of a problem because I don't think a cellular record, whether it be a call detail record, would necessarily show anything. It would show maybe a call takes place, but I can't tell you that that call is about the Walshe matter.
Well, and that's what I wrote in my notes next to C is how would a telephone record tell you whether it related to this case or not?
Well, they just apologized for being unclear about that. I should have been much more specific. I really wasn't looking for phone logs or anything. I was looking for something that was contained on their cellular phones, such as whether it be emails or text messages or the written word that would be indicative of bias and credibility issues. I am not interested in, at this point, of looking at phone logs, and I apologize for not being more clear about that.
So with that, I would inquire of the officers.
All right, so we have a break.
Yes, Your Honor.
The judge is taking a break, and we are going to bring in our trial attorneys who are standing by. National Trial Attorney Michael Jafer and Criminal Defense Attorney Sam Bassett with us as well. We're in an unusual world. We are hearing about the entire phone of these officers being wanted and desired by the defense team. Michael, let me start with you. How unusual is this? Is this something that we just don't see on Court TV because it's the discovery, pretrial hearings, or are we really in an unusual area?
Yeah, we're in a very, I always tell people, look, if you're going to commit a crime, commit it 40 years ago. Don't commit it these days, because the amount of evidence and the amount of arguments around evidence in the last 2 years alone related to phone evidence and Apple Watches and smartwatches baffles my mind, right? We saw a trial where the state was able to pin a murder on a husband by saying that her Apple Watch shows that she goes up the stairs every day around 11 o'clock, but she never went up the stairs, which means she was dead yesterday, not today, not the day that you called the police, right? So you knew she was dead, right? So it's a completely this is the new world. And by the way, it's going to get even more intense. And by the way, I agree with the defense attorney wanted to get all this evidence, but you know, the police officer's cell phone data now, and the prior trial that the same trooper was on, and the messages that they found in his phone, and what it did to that trial and what it could do to this trial based on what it is. So it's a completely bizarre, different world. Basically, criminality, in my opinion, is down to almost a halt in terms of being able to cover up your crimes. It's insane. We see the Koberger case in Utah, and you know, turning off his phone and 4 hours. I mean, it's just insane, Julia. I'm really impressed by the tools.
Yeah, Sam, we understand the defendant's cell phone, even the victim's cell phone being scoured through, but the officers, it seems like it's open season based on what happened in the Karen Reed trial.
It certainly raises the notion that an officer could have some sort of inherent bias in how he conducts the investigation because of how he views the world. And the Karen Reed trial is an example of extreme comments by an officer that should have never been made. There's that internal dialogue versus external dialogue rule. And I think this defense attorney is just grinding away, trying to find that needle in the haystack that might affect his case. It might impact his case positively. And believe me, cell phone data and information on devices is literally not just a haystack, it's a mountain of hay. And sometimes you're just looking for one little kernel that will help your case.
Yeah, something that will show bias. That's their goal. Sam and Michael, stand by. We are going to get in for more of that hearing and see what the judge has to say about these requests and what happens next in the case against Brian Walshe. Welcome back to Court TV Live. We have some breaking news out of a courtroom we've been following all day in Horry County, Ohio, South Carolina, rather, the case against Christopher Dontel. That's the coroner affair murder trial where we expected the opening statements to start today, but then this defendant said he wanted to plead guilty, and we have just learned that he's only going to be pleading guilty to one of the counts against him, accessory after the fact. This is a case where he is accused of conspiring with another woman who was married to the victim in this case. He was having an affair with that woman, and they are both charged with his murder. He is saying that he's on surveillance camera being shown buying supplies at Lowe's that prosecutors say show that he was involved in this murder. He's now pleading guilty to just that charge, and the other counts still in place, including the murder charge. So we are understanding that the jury has been dismissed. They're going to return tomorrow morning at 10 a.m. Eastern. After his plea hearing takes place at 9:30 a.m., they will then start again with opening statements. So we'll keep you updated on what happens there in South Carolina. We're going to go back to now, though, Massachusetts. That's where we're covering the discovery hearing that happened for Brian Walshe in the case of his missing wife. Her body never recovered, Anna Walshe. Now, his attorneys are questioning the integrity of the investigation of this husband. And they have reviewed, or they want to review, more cell phone data from the lead investigator in the case, lead trooper Michael Proctor. He was an important figure in the Karen Reed trial, where it really opened up the question of whether or not he had extreme bias against Karen Reed. And now the Brian Walshe team wants to know if he has bias against Walshe. Let's go back into court for more of that hearing.
Okay.
Moving along, number 17, we withdraw
Yes.
as we continue. Number 18. And once again, if I could just point the court's attention and the Commonwealth to subparagraph G. That is one of G. That's one of the most inartful sentences I've ever drafted.
I don't want to hear what I wrote next to that.
Probably you said something a lot more stern than inartful, but it's what it was meaning, what it was meant to convey was that I'm sure the government is aware of the fact if something in their possession was destroyed or altered, and they would tell us that. I've been working with this DA's office for 2 decades.
Right.
So when I read that this morning in preparing, I cringed because it suggests that they're unaware of their own mistakes. And
That's how I read it.
What I was trying to say was, when they respond that they're unaware of anything being destroyed or altered, at least by their office, I take that at their word, and I understand that. So what we're saying, though, is, once again, a duty of inquiry, and a very specific inquiry of its agents to find out if anyone else is aware of something being lost, destroyed, or altered by way of, whatever that is, if it has to do with the investigation of Mr. Walshe. And I think a duty of inquiry is required under the facts and circumstances, and what history has told us now, the recent history of the conduct of some officers involved in the investigation of this case. And so that's really what we're asking for, just an inquiry at this stage to make sure that there is an affirmative statement on the record that after inquiry, there's no knowledge of anything being altered, destroyed, or corrupted.
Okay.
I appreciate Mr. Tipton, his honesty on paragraph G, as I was confused as well. Because when it comes down to it, at this point in time, I don't know if something is lost or destroyed. So if I find out, that would be exculpatory, and under the rules, I would have to tell him. So I would tell him. I guess what Mr. Tipton is asking me to do is to actively go and ask every officer if anything is lost or destroyed. When I do my inquiry, I will ask if anything is lost or destroyed.
Sounds reasonable.
think that's good for them.
That was faster than I thought. All right. Do we want to address paper 31 and whatever the Commonwealth's been docketed as the next entry, which is the, I'll call it the 2-week request? Now that the defense has seen what the Commonwealth intends to do, is that, I mean, that seems to me the way that we get the information, if they're going to get the information.
Respectfully, Your Honor, they have the information. The information is in the custody of the Norfolk County District Attorney's Office, so not only is TUI unnecessary, it would still be premature when you look at the cases such as Donahue and Lehman.
What if I'm not persuaded by your argument that I ought to be persuaded by this Rahim case, which I frankly am not persuaded by?
So the first question is whether or not the documents are under the purview of Rule 14. We believe they are. We're kind of at a disadvantage because, one, we don't have a copy of the protective order or the non-disclosure agreement. So we're at a loss there because I can't specifically articulate what exactly the protective order is, what exactly it covers, and two, we can't even articulate what is in these materials. The importance of Rahim is that if it is physically in their custody, then they have received it. It is in their control. They possess it. Just because a federal agency says, no, it's really ours, it's not theirs to give.
That was very much so in the context of a joint investigation, right?
It was, Your Honor, but in this case, the government, the federal government and the Norfolk County District Attorney's Office were essentially working together. They were working to investigate a homicide that Norfolk was prosecuting. They were investigating the state police for integrity violations, policy violations, inappropriate conduct, failure to supervise. And so this information has been starting to get turned over to us, and as Mr. Tipton articulated, whether it comes to Bowden or credibility or bias, that's part of what we want to show and what we expect to show. So we believe the material is Rule 14. They have it, ergo we should get it. So I don't think TUI is even necessary yet. If they've indicated they're going to take that road, then that's fine, but that does not negate our argument that it is Rule 14. And the SJC as recent as 2020 has clearly stated that it is in their possession. With respect to the cases they cited in their response, they're relying on Commonwealth versus Bonnet.
We're hitting the pause button on this discovery hearing. We have to get to a break, but we are getting closer to learning what the trial date is going to be in this case. Stay with us.
Tonight on Closing Arguments, a former ballerina convicted of manslaughter after fatally shooting her husband. We'll show you everything you may have missed from the sentencing of Ashley Benefield.
Closing Arguments, tonight at 8, 7 Central, only on Court TV.
There are lots of cases that we'd like to look at.
And you know what it means. You know what you did, right?
I killed him.
And I prayed to God. That's not really how God works. Interview with a Killer. New season coming in 2025, only on Court TV.
Walshe was 39 years old when she vanished between the Christmas and New Year holiday. Her estranged husband, Brian Walshe, was the one who was investigated and charged with her murder. Her body has never been found. And right now, ahead of a trial in this case, his team is trying to get the cell phone data, the text messages, the photographs that may be on the phones of the investigating officers in this case. Let's go back into this discovery hearing for Brian Walshe that happened in Massachusetts.
Bonnet, which was a 2015 case. I don't believe that's on point. Bonnet is a case in which the state district attorney's office was not aware of the identity of a confidential informant. And so it wasn't in their custody. And secondly, they were saying that it was privileged. We have nothing to show that anything in those 3,074 pages are privileged or protected. We don't know. We've pulled it together from pleadings from other cases, responses from the government, just to know that they have it, roughly what it's about, and then several letters between the district attorney's office and the federal government talking about this material, specifically the officers involved. And the reason I can point to, there's a myriad of reasons why it would be relevant, but what we're able to determine is that Trooper Proctor, who was the lead investigator on this case, the moment he stepped foot into investigating Brian Walshe and the disappearance of his wife, he knew he was under federal investigation. And so his bias, his motive, anything or his integrity is forefront for him. So with all those thoughts, when you're considering all of that, I don't know how it's not Rule 14. I don't know how we're not already in possession of this. And so otherwise I rest on the papers. And they talk about Beal, your argument. In Beal, I agree the prosecutor doesn't have a duty to go investigate our case, but they haven't. So we're not asking them to go get something they don't have. And in footnote 4 in Beal, which is cited in their brief, it specifically says the government isn't able to simply put their head in the sand if there is something exculpatory. And documents that show that the lead investigator in a homicide case knew he was under federal investigation the moment he stepped foot in the case is certainly...
Isn't it even strong? Well, I'm not making your argument, but wasn't he already under prosecution?
No, Your Honor. Do you mean
so
Mr.
what's the
Walsh?
yes.
No.
What's the timing of his federal indictment?
Do you mean Do you mean Trooper Proctor or Mr. Walsh?
I thought you were talking about Mr. Walsh.
No,
that
Mr.
there's a
Walsh
bias
is
because he knew that Mr.
No, Trooper Proctor knew he was under federal
investigation.
The moment
I thought you were saying there was a bias against your client because he was under federal law.
No, it's Trooper Proctor.
That's an additional bias, by the way.
Right, but we're just focused on that part. But the moment he stepped into this investigation, and bear in mind, the Norfolk County District Attorney's Office, they control homicide investigations. They work with the state police with CPAC. So now the Norfolk County District Attorney's Office knew that Proctor was under federal investigation, specifically for how he investigates supervision, etc. He now is the case officer in this matter while his case is pending. So that's one of the myriad reasons why not only are these documents relevant, they could very well be exculpatory. And under Rule 14, it's not exculpatory, it's material and relevant. And so with respect to that, I would rest on the papers, Your Honor.
All right.
So, Your Honor, it's my understanding that the federal government has never said that they were investigating officers. That's never been a public statement by the U.S. Attorney's Office in this matter. They have released information to the Karen Reed prosecutors that was subject to a federal protective order signed by a judge that is impounded that I can't see. I have also not seen the materials that were turned over to the Karen Reed prosecution team. So I don't know what's in those materials either. I can tell you that I watched a large portion of the Karen Reed trial, and from what I could see, 2 witnesses identified that they had testified in a federal grand jury in that case when they were testifying in the state Karen Reed trial. It's further my understanding that the federal government acknowledged that they were investigating the death of John O'Keefe, not the district attorney's office and not the state police. It's also my understanding that the U.S. Attorney's Office has not said that this investigation is done.
They never do.
They never do. I can say, Your Honor, I have no knowledge of anyone receiving a target warning as far as being a state trooper, the district attorney's office, Canton Police Department, any civilian witnesses. I have received no knowledge of anyone receiving a target warning. And I would suggest that this is premature, that I have filed a TUI request with the U.S. Attorney's Office for the Walshe materials. I told counsel today I think I should file a TUI request for the Karen Reed materials. And I was willing to work with counsel to make it a joint request. I can understand if they want to do their own. But that would be my suggestion, because I would suggest under ALEA, we haven't gotten to the point of the need for the court to become involved and order discovery to be turned over. Particularly discovery that if it was turned over, the people who have seen it would be a violation of a federal non-disclosure. So I'm not prepared to have someone from my office be charged with contempt. I would prefer that we go down the road of trying to work with the U.S. Attorney's Office and see what those results are, report back to the court, and let the court know.
All right. I'll take a look at the cases that both sides have cited, and I'll include whatever my decision in regard to that in the omnibus order as well.
And one last point, I don't think we can say that the U.S. Attorney's Office and the state police work together on this investigation in the matter of John O'Keefe. It looks like it has been completely two different agencies doing two different investigations. I don't see any, there's been no sharing of information until there was discovery turned over in the Karen Reed trial.
Well, Your Honor, it's not, the case law isn't just about specifically whether or not they worked on this case together, but if there is cooperation in general between the two agencies, which clearly there is. And the problem is, there's too much we don't know, we think. I don't think it's, respectfully to Mr. Connor, I understand he's willing to make the TUI request, but I don't know how we say we're going to make a TUI request, which when you send a letter to the U.S. Attorney's Office saying we believe you have relevant material information, and then at the same time object to the Rule 14 of materials in their custody. That's no foreign.
All right, let's break this down with our criminal defense attorneys and trial attorneys who are standing by. Michael Jafer and Sam Bassett with us. Sam, we've got 2022 when John O'Keefe died. We've got the beginning of 2023 when Anna Walshe vanished, and a federal investigation in the middle raised by the allegations in the Karen Reed case. Of course, she's the one who was accused of John O'Keefe's death. Why isn't it that the defense can easily get these records from the federal government in this state prosecution?
The federal government is restricted in releasing information regarding law enforcement investigations. You can't just subpoena an FBI agent or an FBI file. You have to go through a separate process. That's why they're talking about TUI requests. You have to make a TUI request that has to be approved by or denied by a U.S. attorney. Then you may have remedies in federal or state court to pursue a subpoena for documents or pursue a subpoena for law enforcement governed by federal law. This is getting really complicated because the defense is trying to shoehorn the possible federal investigation of Detective Proctor into getting more information about what they're looking into with regard to his possible misconduct or bias in his law enforcement investigations.
Very complicated, but Michael Jafer, we've seen this before. Let's say they look through all of this data, they get the information from the feds, and they do find at least one text message where there's something that shows some bias. Are we going to see a completely different defense from Brian Walsh's team, similar to what we saw in the Karen Reed case?
Absolutely. You throw everything you have at the fence when you're the defense, because in this specific case, they're starting from way behind the prosecution, right? They have a client who has a lot of pot marks on him. His case has pot marks. He obviously has the previous conviction of basically being a thief. So you throw everything. You're hoping to get a text message. You're hoping to get a note. You're hoping to get something that's inflammatory that you can throw in there to show that, hey, you know, this person was a very bad investigator in this other case, and he was a bad investigator in this case. He was tunnel vision. We don't have a dead body yet. We, he knew that he was being indicted for being a thief, and so he tunnel vision, and he looked at him and look at this text message, look at that text message, look at this email. So absolutely, you throw all of it.
Sam, though, do you see differences in the way Karen Reed's case played out, where you had officers that they were pointing the finger at, trying to shield themselves, Brian Albert's home being where the body was found, and this case where Brian Walshe doesn't seem to have any connection as to why there would be a reason to try and frame him?
It is a bit of a reach in this case, I think, but that's what defense attorneys have to do. You have to dig and hope you find something that it is directly connected to your defense or creates a defensive theory that you may be developing. This is the nuts and bolts of discovery, litigation, and defense work. And although it's not an obvious connection yet, as it was in the Karen Reed case, the defense lawyers are just hoping to develop one.
Many connections between these cases, especially there in Massachusetts.
We are in Massachusetts this hour, where a man accused of killing his missing wife was back in court yesterday for a discovery hearing. Brian Walshe is charged with first-degree murder in the presumed death of his wife, Anna. She was last seen on January 1st of 2023 having dinner with her husband and a friend. Investigators say that Brian killed his wife that night and spent the following days concealing the crime, including making a fake ransom note. Her body has never been found. Walshe was last in court in October, where his lawyers raised questions about the integrity of the Norfolk County's investigation. That's the same county that handled the Karen Reed investigation. Now, that October hearing was continued until yesterday in order to give the parties time to review the very large amount of discovery, which included cell phone data from Trooper Michael Proctor. You may remember Trooper Michael Proctor was the lead investigator in both the Reed and also the Walshe case. Here is Court TV's own Matt Johnson with a closer look at the timeline of the case.
No comment from Brian Walshe after he was charged with the murder of his wife, Anna Walshe, the missing Massachusetts mother of 3 young boys. And while he's not talking, prosecutors are piecing together a timeline of what they say he was doing in the days after her disappearance. Prosecutors say that Anna Walshe was last seen here at her Cohasset home on New Year's Day. Anna was last seen at home between 4 and 5 a.m. by a family member. Walshe told police that he had slept in that morning, but prosecutors say that he was actually awake and searching disturbing topics on his son's iPad.
At 4:55 a.m. on January 1st, he searched how long before a body starts to smell.
The very next day, more Google searches.
There were also more Google searches on January 2nd. At 12:45 p.m., Pat saw best tool to dismember. At 1:10 p.m., can he be charged with murder without a body? At 1:14 p.m., can you identify a body with broken teeth?
Prosecutors say that on January 2nd, Walshe came here to this Home Depot store, located in Rockland, Massachusetts, 9 miles from his house. He spent $450 on cleaning supplies.
Items included cleaning products, mops, brushes.
On January 3rd, prosecutors say Walshe drove to an apartment complex in Abington, 16 miles from his home, where they say surveillance video shows him hoisting a heavy garbage bag into a dumpster. At 4:48 p.m., prosecutors say Walshe drove to a second apartment complex in Abington. And at 5:10 p.m., investigators say he threw items away into a dumpster in Brockton. Then on January 6th and 7th, police searched the Walshe property in Cohasset. Prosecutors collected a lot of evidence in the basement of this home, including DNA blood evidence and 2 knives. On January 8th, Walshe was arrested for misleading police in his wife's missing person investigation. The next day, he was arraigned and pled not guilty. Then on January 17th, prosecutors announced that he would be charged with her murder. The next day, he was back in court.
The defendant is now before the court charged with murder of his wife, Anna Walshe, as well as disinterring of a body.
Let's get you back into that courtroom now for more of the hearing.
I don't think it's right to be like, well, someone else in my office knows, but I'm just not going to talk to them about it. I understand if there's protective orders and if the government wants to rely on that at this point, but I think that not only is there evidence that these 2 agencies routinely do work together, I think the fact that the officers involved in both cases were under investigation for whether it's integrity, investigation, failure to supervise, I think that does count as working together for this case as well.
I would just disagree with that.
All right.
If I may, Judge, just briefly, I don't want to step on anybody's toes here, but when Mr. Connors just said that we didn't want to work with him, I will say we will work with him. I just don't want, and Attorney Porges don't want, that our efforts to work with the Commonwealth dilutes our Rule 14 argument. That's all.
get the lower hanging fruit, the Rule 17, when do you want to schedule that?
I reached out to Chief Legal Counsel for the state police. They asked for 4 weeks.
Okay.
So with
What does that bring us to?
4 weeks would bring us to the beginning of January, the first week of January specifically. January 6th through the 10th. I'm available.
All right. So, I want to get a date on the calendar, and recognizing you're likely going to be up and moving for that one.
Yes, Your Honor.
And so I just want you to know that in advance. I'm happy to do what I typically do, and frankly what I'll be doing when we try this case, or whatever that is. I try cases from 9 to 4. And what I do to accommodate the other business, depending on the length of the case, is try to go on the bench at 1:45 and clear away the more straightforward matters, and frankly put off the more substantial matters to a time when you're not on trial. And the goal there is to keep the case moving and to be as most respectful, frankly, as I can to the jurors who are making a big commitment of their personal time. So it becomes a little bit of a juggling act, but it's doable. You just do it for the 2 weeks. This feels like a 2 to 3 week trial for me. You're going to tell me later on down the line what it really is, but just on the limited knowledge I know, 9 to 4, Monday through Friday, it feels like 2 weeks, but I don't know enough about the science yet.
We're anticipating 4 weeks. And
on a full day schedule?
On a full day schedule. We were just talking about that before we came.
You're probably right. It doesn't feel that way to me, but that's only because you know a hell of a lot more about the case than I do.
We also know each other. We've done a lot of things with each other as far as trial work, and we know that neither one of us kind of waste each other's time, so we just believe that we're probably in that realm. We also think that impanelment will take 5.
And that my estimate was after we get the impanelment, which could be a lot.
Yours after?
I was trying to include impanelment, so I think that if you're thinking about testimony, it's probably about 3 weeks.
So it feels like it.
Yeah.
But again, your estimates, I'm going to take your estimate to the bank because I'm just entering the case, and you know so much more than I do about what it's going to take to try the case.
Yes, sir.
So, but that's important, and it's a good segue. Anyway, let's get to, the reason I mentioned that scheduling issue is I can see you at 9 o'clock in the morning if you want to do that, and I'll just delay my trial on that day till 9:30 or 10 if that works. If you don't like that, and I get that, because you're going to have to deal with the 120 in traffic going up there, which is not good. I could see you at 1:45, and I'll give you 1:45 to 2:15. Or I could see you at the end of the day. Pick your time slot.
Whatever works for Mr. Tippett, I'm happy to do it.
The 1:45 certainly works for me.
All right, let's do the 1:45.
Which day?
Any day, but Wednesday or Thursday or Friday that week would be best, because the panel on the case from is probably going to take a couple of days.
How about January 9th, which is the Thursday?
That's the one date I couldn't do that.
That's why I picked it. How about the 8th?
January
the 8th.
At 1:45 in
Wednesday?
Yes. And if the defendant wants to be there, obviously we can get him there. If you want to waive his presence for that, that's fine too. You just let the court clerk know and each other.
And just so the record's clear, I do have a manslaughter case scheduled for trial for January 7th, but I'm probably going to learn within the next few days if that's going to go or not, but I don't anticipate it going. I just want to...
Okay. If it is, we'll find another. I just want to keep everything moving to the best that we can, but and I will be agreeable. You're on trial, given the nature of this dispute. Also seeing you on Zoom. So, given the nature of the dispute, I don't know that we all have to be physically in the same room. I prefer that, but it certainly isn't necessary to get your points across.
Thank you.
All right. But right now, we'll presumptively say 1/8/25 at 1:45 in Middlesex, and I'm going to be in Middlesex 5:30, I believe. But definitely on the 5th floor.
Oh, okay.
All right? So let me move to the schedule. Let me see if I can find proposed scheduling order. Every judge has pet peeves. We all do. You do too. Yeah, your own pet peeves or your practice. One of my pet peeves is serial motions to suppress. I like to do them all at once. I never understood why you have a motion to suppress this, that, and the other thing. Just do it all together. Evidentiary, non-evidentiary, put it all together. So I want one date for the motions to suppress. Or put it all into, break it out if you want to break it out. But it's all going to be argued and heard on the same day. And so that's going to compress the schedule. The other question that I had about, these are just general.
All right, the judge saying, listen, it's a hard balancing act. I need to ensure the defendant gets a fair trial, but also I've got to keep the case moving. These are discovery issues she's discussing. We're going to take a break. When we get back, we'll get you back inside this courtroom in the Commonwealth of Massachusetts.
Tonight on Closing Arguments, a former ballerina convicted of manslaughter after fatally shooting her husband. We'll show you everything you may have missed from the sentencing of Ashley Benefield.
Closing Arguments, tonight at 8, 7 Central, only on Court TV. Join Court TV's Vinnie Politan with the latest and breaking true crime stories.
Now, let's look at the other side of all of that.
Vinnie Politan Investigates, tonight, 9, 8 Central, only on Court TV.
Massachusetts, where we are watching a discovery hearing in the Massachusetts mom murder trial. Defendant Brian Walshe is accused of killing his wife, Anna, and dismembering her body back in 2023. We want to get you back inside court now for more of the discovery hearing.
This is a relatively brief period of time, as you have it scheduled right now, between the motion to dismiss and the motion to suppress. So in my judge mind, I read one of two things. They don't think one is really coming and it's not going to change the schedule. Or there is one coming and obviously we're setting ourselves up for, we're not going to even get to the April date. So those are the thoughts that are running through my head. This case ought to try in 2025. I think we should pick a trial date in around a year from now. Now that you're telling me it's 4 weeks, I'm much more likely to look to November as opposed to sort of when I was driving down here, I thought first week of December we'll get this in before the end of the year. Maybe somebody could take a look at the calendar and see when Thanksgiving is. Maybe we do the Monday after Thanksgiving. I think we'll get it in 4 weeks, clearly there. But I think that kind of schedule should give you a reasonable amount of time to get the work on the important work that you need to get done, but keeps this case on a little tighter schedule. It's going to be, as I said, I think the case was arraigned in April 27th of 2023. So I guess the suggested time that I'm giving you is 2.5 years. That seems like enough time. Now, I've said it a couple of times, I'm going to repeat it again, and I'll certainly hear you. You know the case better. When I see things in motions that say there's 27,000 pages of documents in this case, what does that really mean? I don't know, because I don't know what's in those 27,000 pages. Not all 27,000 pages are the same. You know what I'm talking about. And I don't know how much more is coming. But you can compare it to other cases tried here and certainly elsewhere in the Commonwealth and say 2.5 years, it's time to go. And that's what I'm suggesting. So I'll hear from both of you. Who wants to go first?
Well, Your Honor, I can say that as far as the discovery goes, it went in a couple different directions being the grand jury, which was about 1,000 pages, but I think it was a complicated case as far as pulling it together because there was a significant white-collar portion to it. So with that, I understood how the discovery got up to there in numbers, but that being said, Mr. Tipton and I have had a long-standing relationship and working on cases together against each other, and I think that we have a really strong relationship on trying to get to the heart of the issues. We talked about trying this case in 2025, and we were looking at potentially late October, and I'm looking at the calendar right now in front of me, and I think October 20th, 21st is the second to last week in October. To me, that gives us about a month before Thanksgiving, which is a nice target. I think it also makes it easier to get panel jurors. I think once you start crossing towards holidays, it becomes a little more problematic. So that would be my suggestion as far as the trial.
And just so you know, that's 6 weeks before Thanksgiving. That date that you just picked.
October 20th, 6 weeks before Thanksgiving?
Yeah, late Thanksgiving is again a late one. It's November 27th.
So that's, given the panel being a long time, could be like over 5 days, could be 7 days, I don't know. I think that gives us enough time.
After talking with the district attorney and our client,
If that date is good for you, it's good for me. It's not mine.
Someone's media box has a phone or some device that's vibrating, so if we could shut that off, that'd be great.
I think it's not now. It's not. All right.
Do we want to work backwards?
Yes, we're going to work backwards right now. So what was the date that you just said?
So October 21st, Tuesday, October 21st.
Okay.
If I could,
I just want to add, does anybody want me to ask Sylvia to start on the 20th?
Might be a good idea.
Yes, please. It's been a few years since I sat here, so it's, what is it, Monday is the civil
Monday's
day?
civil, Tuesday
Tuesday and
is
Thursdays.
criminal stuff, but
It
exceptions.
wasn't that long, I guess it was about a year and a half ago, just seriously. All right.
Judge, if I could just, before we start nailing down
dates, yes.
And just so you know, the Commonwealth, we all met, and we hashed over a bunch of dates too, hoping that the court would find those dates for you. But having said that, briefly, I'm just going to say this: I didn't have the case for date.
I know, you came on board about a year ago, right?
I was in the middle of a double homicide when the case came up, and I really didn't look at anything for a few months. And when I say 27,000 pages, that's an underestimate. And included in some of that is video surveillance, hours of video surveillance. There's also transcripts of statements that still need to be properly transcribed in some instances. But aside from that, the forensic testing in this case.
Thank you for mentioning that.
Is extremely complicated and it's still ongoing. And the Commonwealth and I, Attorney Porges, we're trying to work out an issue with the DNA testing and the exhaustive testing that is a very critical aspect of this case, and we expect to be able to, file a motion to address the issues we have. But the short story, judges, I hope the court understands. When we selected the dates for the proposed scheduling order, that was after we met a number of times. We talked about what the case was, our understanding of the case, and I want the court to know that we didn't suggest dates as a subterfuge to suggest, we'll just pick this.
And I don't think that anything I said in substance, or certainly in my intent, sometimes it gets lost in my translation, in my delivery, was meant to suggest that that wasn't in the realm of possibility. I just think that it's probably not the best thing for the case. And I'm going to be here to try the case, whether it's in October or it's in April. But it's going to be tried in an efficient manner. And people, there's a reasonable view to it. It's my pet peeve. I don't like serial motions to suppress. It's just as simple as that. But some people like serial motions to suppress. You don't know who you're getting on the other side of the bench. Some people like to take it in smaller tranches. I'm just telling you that I think there's a way to be more efficient. Of course, I'm not going to force or pressure anyone in this case within reason, and I'm never going to have to do it with counsel that I have here to make you do something that you're not comfortable going forward. I think we can be more efficient with the schedule, and I'm going to do my part to turn around the motions you do present to me quickly.
And on the just now limiting to the issue of motions to suppressing the dates, after the Commonwealth and I and Attorney Porges all talked, we think there is a need for 2 separate dates. And if we could, I would ask to come to sidebar to tell the court, to give you a reason that I'd like to do it sidebar.
All right.
While they're at the sidebar, let's bring in our experts this hour, trial attorney Michael Jafer, criminal defense attorney Jeffrey Wolf. Thank you, gentlemen, for joining me here as we continue to break this down. Jeffrey, let me start with you because I kind of have to smile. The judge even said graciously, well, sometimes things get lost in my delivery, trying to explain some of the trying to get this scheduled. It doesn't matter if it's October or April. I'm going to be hearing this case. But I think she's just being gracious. Jeffrey, what do you think?
Yeah, I think everybody in that courtroom is trying to be extremely magnanimous with each other and trying to keep everything professional and get along. Nobody wants to appear as the person that doesn't like the defense or doesn't like the prosecution or doesn't like the judge. Everybody's trying to keep things professional and get along at this stage of the case. Obviously, we see these things devolve over time with these cases, especially the longer they go on. But as of right now, everybody wants to get along and everybody's doing their best to do so. I think that's very clear.
Yeah, I think you're right. I agree. Michael, weigh in on this part because the defense was just arguing to the court, listen, the forensic testing is extremely complicated. And that is something I think absolutely is probably true in preparing a defense in this case.
Oh, it's very, very problematic. It's very difficult, especially the fact that they haven't found a body yet, right? So the defense attorney was laying that out to the judge and letting her know that, look, we're going to try to make the deadline, getting the trial before Thanksgiving of next year. But this is very complicated. I had this other trial, then I have this other trial coming up, then I have a manslaughter trial coming up in January. So this is a very complicated case. And sometimes defense attorneys are compelled to remind judges that, hey, I know you want to get to lunch, but at the end of the day, we might need some time. And this case is very complicated, and we heard earlier about the difficulty of getting the evidence from the, with the 2E letter and getting the stuff from the federal investigators. And so some trials, sometimes, especially when you have bureaucracy, especially when you have forensic testing and all this stuff, sometimes you need a year to prepare for a trial. It's not unconscionable to even believe that. So I could sympathize with him and what he was saying.
And, when I was on the bench, I remember best intentions. We'd all be on the same page of when something would happen, could happen, should happen, and inevitably there'd be a delay because of something not necessarily within our control. But speak to the fact, Jeffrey, this is a circumstantial case. There is no body. How hard is that to prepare as a defense attorney?
It's incredibly difficult because what you're ultimately going to be looking at, and this is why we're talking about forensics in this case, because the state's case is going to be entirely dependent on how they tie him to this murder, because it's going to be completely circumstantial. And so they're going to be looking at those computer searches that we heard about. They're going to be looking at the videos, the surveillance videos. They mentioned hours and hours of surveillance videos because we have the trash bag that he's seen with. They're going to be looking at, minute amounts of potential DNA or blood that they may have found. That we see a lot of that in these cases. People do their best to clean up a scene, but there may be something found, whether it's cleaning material found out of place or blood found out of place or a hair or a fragment of skin. You never know what the crime scene investigators found. It's 2024. It's very, very hard to clean up a crime scene and not leave any trace of a murder.
Yeah, I agree with you. Absolutely. And they have to look at every bit of it, because if the prosecution fails to deliver on any one of the things, that's something the defense can grab onto to say jury reasonable doubt. Thank you so much, Michael Jafer, for joining us today. Jeffrey, you'll be sticking around. We're going to take a break. When we come back, again, some of the most important decisions are made at discovery hearings. So when we come back, we'll get you back inside the court in the Commonwealth. Stay tuned. Welcome back to Court TV Live. I'm Ashley Wilcott. Thank you so much for being with us. We are in Massachusetts this hour covering the discovery hearing for Brian Walshe. He's accused of killing his wife, Anna, last year. Her body has never been found. Right now, the judge and attorneys are hashing out some scheduling matters, including an official trial date for Brian Walshe. Let's go back into court together.
Go back to that so that we'll seek the 10/20 day for impanelment, and then we'll seek, I'm going to put you on that final pretrial conference. Let's do it 2 weeks out, because there might be enough instead of, I don't know what they normally do it here. It's usually the week before. But this one, we'll put it 2 weeks out.
Mr. Tippett and I go on, start around 6 months out, and keep you busy until that. So don't be surprised if we...
I'll be watching. I'm just like, we'll be on the final stretch of motions eliminate. On, let's do it Tuesday, the 7th, is that right?
Yes, October 7th.
And then...
9 or 2.
I'm going to say 9.
I agree.
Okay, so 9 a.m. for that, and that'll mean that you're going to have to back this out, but get your motions eliminated with any objections to me by the Friday before that. Earlier, if you can. If you can't, I'll just read them over the weekend.
So file everything by the 3rd, all motions eliminated by the 3rd.
Yes.
And any jury instructions, proposed voir dire. I don't know if you're going to want to do a questionnaire. If you do want to do a questionnaire, you can reach out to the court. I have a couple of ones that I've used recently, and homicide cases, and I can give those to you. It does, in some ways, make the impanelment, I don't know if it goes faster, but it raises issues in a more sensitive way.
I appreciate that, Judge. We've been working on a questionnaire already.
Okay, great.
I would appreciate anything.
I'm happy to share them. They're available, and I think that every time you look at a different questionnaire, different issues come to light that you think might apply to your case, so I'm constantly tinkering with it. But I'll share feedback I've had in the last couple of years.
So, were you going to pick a date, give us a date for the filing of...
Everything's on that Friday before.
Okay.
Your Honor, if there are objections to anything that's filed on Friday, understand what it's written objection will be getting to you.
Right. So what I was trying to build in was, and since I know that you work collaboratively, is I'd really like the whole package, like the 9A package, so to speak, together on that Friday before, so I can consider the objections, the oppositions. So if you can work collaboratively so that the oppositions are filed, maybe you give them to each other the week before. Okay. Your motions, if you want me to put that as a date. So initial motions eliminate are the Friday before, any oppositions are the Friday before the 10th.
The objections by the 3rd.
Yep.
So the 28th of September would be...
Yeah, you did that by September 26th. You'll file all motions eliminated and your objections or oppositions filed by the 3rd.
That works for everybody?
Yes, Your Honor.
Yes. All right. Let's do, I think we agreed to 1-2 on the motions to suppress.
Your Honor, we had 2 tentative dates for the court.
Sure. Thank you.
For the first motion to suppress, which we believe, forgive me, would be evidentiary.
Yes.
We were suggesting April 7th. And then the following would be, for the remainder of the motions to suppress, May 12th. That would give counsel and myself 30 days to respond to anything that could come up.
Okay.
Especially if you had a decision, you would have time, the counsel would have time, or you would have time to examine it.
So, hold on a second, I just need to check something. Get the calendar from the... Okay, 4/7 is a good date. That's on the evidentiary one?
Yes, Your Honor.
All right. I am not going to be here, but I'm going to be close by in that quarter as well. So just stay tuned for a location. But it's going to likely be in Middlesex as well.
Yes, Your Honor. 147, right?
Yes.
Yeah. And that's 9 a.m.?
Yes.
Yeah.
And then 5/12. I can do that. I have to move something around, but I can do that. 9 a.m. also?
Yes, Your Honor. Also Middlesex?
Yes.
Thank you.
All right. Dates on the motion to dismiss.
So, Your Honor, I haven't talked to Mr. Tipton or Ms. Borges about this, but I don't know how they feel about July. So, July 14th, let's get kind of smack in the middle of it. It's Monday.
Before we head to break, new developments out of Massachusetts where the judge in the Karen Reed case has denied the Commonwealth's motion to access Reed's parents' phone records ahead of her second trial. Prosecutors had filed a motion seeking a month's worth of William and Janet Reed's phone records from 2022 in hopes of showing that it was unusual that Reed had called her mother 3 times on the night that her boyfriend, Boston police officer John O'Keefe, died. The Commonwealth went on to say that this would provide strong evidence that Reed, quote, knew she had done something terrible, struck John O'Keefe, or left him behind, unquote. And now I'd like to share my thoughts from the bench on this ruling. This is a really great example of you can't just get everything you want to try a case because you think it might be helpful or because you ask. Evidence that you are seeking to obtain and or use in trial must be relevant. That means it must be logically connected and tend to prove or disprove the matter in issue. If there's too big of a disconnect, then it's likely not relevant. Note that the judge in this case found that the affidavit in support of the state's motion to get 1 month of cell phone records of the parents of Karen Reed is, quote unquote, insufficient on its face and fails to meet legal requirements. But even more important to note is that she made that finding because she said the affidavit did not show that the records were relevant with specificity, meaning you have to be very specific as to how and why they're relevant. This is a case I absolutely agree with the court's ruling because you're taking into account as well that the prosecution already has the phone records and cell phone data from Karen Reed's phone. What a stretch to say we also want it from the parents' phones. I don't think it's relevant. I think the judge made the right decision in this case. Let us know what you think. We're going to be right back with more right after this break.
Drew me to Court TV was this opportunity to combine the two things that I love. When I was in college, I studied television and radio, and then, of course, went to law school. And when I found out that Court TV was going to give me the opportunity to express myself and to share my love of the law, I was sold immediately. The most important issue, innocence or guilt. Started as a production assistant, then AP, and then went up the ranks, and really haven't looked back since.
Back now to Massachusetts, where we are following a hearing for defendant Brian Walshe. He is charged with first-degree murder in the presumed death of his wife, Anna. She was last seen on January 1st of 2023 having dinner with her husband and a friend. Right now, we want to get you back inside the courtroom for the remainder of the hearing.
Again, 9 a.m.?
Yes.
Yes, please.
Just stay tuned for where that's going to be.
Oh, yes, sir.
But I'll try to get up there. So you don't have to be where I'm going to be.
Thank you.
All right. Any other dates we need to put on?
I think
We have a potential motion about the DNA testing, Your Honor.
What is going on with DNA testing? How long has the lab had it? What needs to be done? What has been done?
So the lab has tested samples from objects taken from garbage that was located outside the defendant's mother's apartment. They've also tested samples from inside the family home in Cohasset. What is at Bodie right now is tissue that was found on a saw in the garbage at the mother's apartment. That can't be done by our state lab. Essentially, these items put in a wax paraffin block, and Bodie has the ability to take slices from the block and do DNA testing from that. There are 6 samples that have the potential of having results. And so where we're at is that they have the potential of also being destructive testing at Bodie. And so that's where we're at as far as potential promotion. Bodie has a different, and Mr. Tiffin can probably speak to this better than I can, has a different policy and procedure for outside experts coming in and doing their testing. And also, there's a cost. And Mr. Tiffin and I have been talking about the cost. And it has to get paid one way or the other. The question is who's going to pay it? Is the government going to pay for all of it? And so we're trying to figure that out. And that might be the subject of the motion.
Okay. Anything you want to add to that, Attorney?
So the money issue will be resolved. I mean, we want $20,000 just to have someone stand there and watch. However, the real issue for us is the observation and what Bodie requires and limits any observer to see as compared to the Mass State Police and some other ones. So we anticipate filing a motion. We discussed it with the Commonwealth, arguing that Bodie needs to at least change their protocols for this case, especially given the gravity of this evidence that's being examined. And we'll file a motion, and that's the 2 issues. The cost, which probably is not much to talk about. It's the other one that needs to be addressed.
Okay. When can we tee that up?
I think we should probably do it on that same January date. On the 8th, because I don't think it's going to, I think I'll file something that's, I can rest on the pleadings and we'll just be brief.
All right, let's do it then.
Yes, Your Honor.
2 of you work together with regard to when it's going to be filed and give each other enough time, honestly, to propose.
Yes, Your Honor.
All right, any other dates we need to set?
The only other thing is a discovery date, but I guess maybe we should wait and see. I know there's 2 at least, but there's other production of discoveries coming. And I think when we come back, January 7th, we can put a realistic findings.
All right, I think that makes sense, Joe, and I think you'll have the benefit of my ruling at that point and know what additional I think you ought to be producing.
Yes, Your Honor.
The addition of that motion, does that change the Zoom option for January 8th?
It doesn't in my mind. If you feel differently, let me know.
I don't think
I was intending upon being there, but I know...
You're welcome. You're always, all of you are always welcome, wherever we are. But if it becomes an issue that we would have to cancel the hearing versus doing it on Zoom, then it would be my strong preference to do it on Zoom. So you have that option. Just let the clerk know what you're doing. And obviously, it does create, obviously, some problems if defense counsel's on Zoom, and the defendant had a number of issues with the facility not putting them on, and then it gets delayed. And so sometimes if there's two counsel, one will come up and the other will be on Zoom. Just work to make sure that everybody's coordinated so we don't lose the date.
Yes,
Ever have the defendant transported to Middlesex and nobody's there. I'm sure that won't happen, but given that there's some moving parts, I would just alert you to the prospect.
Now that you've said you're sure it won't happen.
All right. So I'll see you all on the 8th. But before we close, is there anything anyone else wants to raise that I did not raise?
Yes. Is a housekeeping matter by protective order?
Oh, yes, Your Honor. We submitted 2 protective orders. They're agreed upon without prejudice, but it relates to internal affairs discovery and potential bias that we've identified.
Okay. So just take a look at them.
Yes, Your Honor.
Joining us now on set, Court TV crime and justice correspondent Matt Johnson, who's been following this case closely for us. Really great to see you as always, Matt. Tell us,
to see you.
A lot going on. What are the key takeaways that have stood out to you?
Well, this Judge Frenier, who has just inherited this case, she's specially appointed to this case because, remember, it was Judge Beverly Cannoni that was overseeing this case and this trial. Now we have a court date, and this judge means business. Quote, nothing gets better with time, Judge Ashley. That's what she said. And this case has to move forward. She wants to see it on the docket. She wants a trial date set in October, and we now have that. October 20th, 2025. She's saying that it's going to be about a 3 to 4 week trial, 1 week jury selection. That's what we saw in the Karen Reed case. And she was talking about a lot of these upcoming hearings are going to have to take place in her home area where she has her courtroom, and that's in the Middlesex area, which isn't too far away. But the judge was saying that I understand that you guys are going to have to drive to me, and we're going to have to discuss this. But the next trial date for the next evidentiary hearing or a follow-up with this, because she took it all under advisement, is in January 2025.
All right, took it all under advisement. Talk to us, Matt, about really there's, you know, they were just talking about oxidation being an issue. There's a lot of evidence in this case.
A lot of evidence in this case, and you heard right there the Commonwealth saying we don't know if we have the money to test for the DNA and some of the tissue matter that was found on potentially either the hacksaw or the bent knife that was found in the home shared by Anna, who is still missing, and Brian Walshe. There is a lot of evidence in this case. I mean, today we're hearing arguments about getting records of Trooper Michael Proctor, who was the lead investigator in Karen Reed and has since been placed on paid leave, not allowed to function as a trooper, relieved of duty pending disciplinary action. He investigated this case. He was the lead, and they want all of his records, including cell phone records, because they want to be able to look and see if there's any exculpatory evidence to help with their case. But at the end of the day, this case, there is a lot of evidence, including blood-soaked rugs from the home, a broken knife, a bent knife, a hacksaw, the searches on the son's iPad, including dismemberment and best ways to dismember a body, and then you have the all-important insurance policy of $2.7 million.
God, you had me at hacksaw and knife. Thank you, as always, Matt Johnson, for your great report.